Welcome to Law Line with your host, the distinguished New York lawyer, author, and lecturer, Alan Schneerman. Each week, Law Line will bring to you the most knowledgeable experts in the field of law today. And now we introduce today's guest and our host, Alan Schneerman.
Welcome to Law Line. Every week you read about another $1 million verdict or settlement in a personal injury case. Today we are privileged to have as our guest the Honorable Gerald Held, Justice of the Supreme Court of the State of New York, sitting in Kings County, and Harry Lipsig, who was recently called by the New York Post the Emperor of Torts. Our distinguished guests will discuss how these $1 million settlements and verdicts come about. Hello, Judge Held. Hello, Harry.
It's a pleasure to be here.
And for me, a particular pleasure, because not only are you an excellent host, but hang it all, man, you've got the reputation of being a deuce of a lawyer besides.
Thank you very much, Harry. Judge, I know you participated in $1 million verdicts. What goes into a $1 million verdict?
A good trial lawyer who's able to explain to a jury what injuries his client has sustained and the future of that client.
Of course, I've often been told that a case in one attorney's hand can be worth $500,000, and the same case can be worth double that, if not more, in another attorney. Is it a matter of presentation? Is it, what is it?
Well, I heard someone say that all lawyers are good, but some are better than others.
And with that, I'm going to turn to Harry Lipsig.
Well, that's a very generous remark, Judge, because I too personally like lawyers, and I'm forever blasting forth before the public that lawyers are criticized for doing those things that their clients wanted them to do. And they're criticized because of their zealous activities on behalf of the clients, and when they don't do it, the client is disappointed.
Harry, I know you get, on a consistent basis, $1 million verdicts and settlements. How do you do it?
Well, first of all, I've got a splendid staff that gives me a splendid foundation in the basic work that they do in connection with all of the preliminaries on those cases. Additionally, with the judges we have today are even better than the judges that we had in the days when I first started in practice. Additionally, the public has become aware of the value of pain and suffering and what it really means. And you know, one of the things about which I am most intolerant is the war cry, the bleatings of some of the people who speak of these terribly large verdicts and who ignore the horrible existence of a pain-filled body over a period of years. And the public has become aware of the meaning of that, and lawyers have become aware of techniques to bring it home. You have things today that we never had in the past. You even have a type of heat that is able to display on a screen the intensity of the suffering of a human being. And the lawyer of today is almost a scientist in his ability to recognize the instrumentalities that are available to him. Another thing that we have today that we never used in the past are experts, financial experts, who can discuss the loss of earnings and the cost of medical over a lifetime and can portray them before a jury. And the lawyer of today, who is a trial specialist in this field, has to know all of these techniques and must be aware of all of the things that are available to him, including even the use of X-rays in the courtroom and the use of the necessary display of injuries in that manner as well. There are a million things that lawyers today have available that weren't available in the past. And above all, you have inflation. And the verdict of the past is not the verdict that should obtain today.
Well,
To paraphrase what Mr. Lipsig just said.
Please call me Harry, Judge. At least here, though you don't ever do it in court.
Well, to paraphrase Harry, the necessary ingredient is preparation and more preparation. And ever-continuing knowledge by today's trial lawyers of the scientific tests that are available and the expert testimony that is necessary to establish in a jury's mind the true value of an injury.
Judge, I know personally that you preside over settlement discussions on a day-in, day-out
And
basis.
does it beautifully.
And
Well, I
when,
presided over enough of yours, Alan, and I
Yes.
haven't heard any complaints from you yet.
no complaints whatsoever. But one question that I have, and many attorneys have as well, is when you give a recommendation on a case, a figure for settlement. Now, we're not talking about verdict that comes from a jury. We're talking about a recommendation for settlement. What goes into your thinking to give that recommendation where one injury is worth this amount, another injury is worth that amount? How do you evaluate this?
Well, it's a sum total of many years' experience and concentrated experience. As you indicated, I preside over these settlement discussions and negotiations on a daily basis, maybe 30 or 40 or perhaps even more per day. That's on a slow day. And we follow jury verdicts. We know what type of a verdict a particular injury should bring if the question of liability is established. Liability, of course, meaning fault or blame on the part of the defendant. Sometimes, because we have a system in the state of New York of comparative negligence, sometimes a jury determines on a basis of 100% the percentage of negligence which is attributed to the defendant and the amount of comparative negligence on the part of the plaintiff. Thus, if a jury would give a $100,000 verdict and they find 50% negligence only on the part of the defendant, the plaintiff will only receive $50,000. So we have to evaluate the question of liability first, and then we take that percentage and apply it to the value that our experience has shown us for a particular injury. We know what a fracture of the leg should bring, what a fracture of the ankle should bring, what a fracture of 3 broken ribs should bring, what a laminectomy should bring, and we apply it accordingly. We also take the intangibles, the attorney who's representing the plaintiff. See, what the public has to be aware of, and it's most important that the public be aware of, that there are no particular recognized specialties within the law. When I say recognized, it's not like a physician who is a diplomate in a particular field. A lawyer can hold himself out to be a specialist, while in fact he has experience in a particular field. He's not recognized as such by members of the bar as a specialist unless his peers actually acknowledge that. So we may have the lawyer who handles the real estate closing, and he does a wonderful job for the family. And then the child of the family crosses the street, is struck by an automobile, and they go immediately to that wonderful lawyer who handled the real estate closing so well. That wonderful lawyer, unfortunately, has no experience in negligence matters. If he is a good lawyer, a conscientious lawyer, and a smart lawyer, he will bring in a trial lawyer as his associate on the case and refer it to a fellow like you, a fellow like Harry, for the purpose of trying the case.
Of course, the jury system is all important. And Harry, would you agree? It's often been said that your expertise in selecting the right jurors, that's
It's vital. It's vital. One juror can cripple the best case that you may have.
Well, can you give us a little insight? We have a lot of lawyers watching. How do you select a jury that's good for a plaintiff's case?
Well, for one thing, instinct plays its part. And we lawyers who are picking juries every day will look at a man as he's entering the jury box or as we're about to question him, and we immediately get the feeling, well, this is a plaintiff's man or this is a defendant's man. There are many signs. The expression of the face, the position that they assume when they enter the jury box, the manner in which they walk to the jury box. Everything about him tells us a story. The appearance, the expression in his eyes. Now, if a juror
Excuse me,
would...
Harry, are you saying that you don't pick a juror with the head, rather you pick him with the gut?
We do it with both. Everything plays its part. Our inner feeling as well as our... I have a terrific respect for the subconscious, Judge, and I think there is nothing that determines our thinking more than our subconscious. I'll never forget that. And I learned it in a recent case with a rather unusual experience. Do you know that I tried my second criminal jury trial in my whole career? I tried one 45 or 50 years ago, and I tried one here a couple of years ago, and I claim that I won that case, and my subconscious won it rather than my conscious by a bit of athletics that I decided not to indulge in, and in which my subconscious sold me down the river, by my suddenly finding myself saying to the witness, having decided not to say it, unconsciously, my subconscious propelled me into it. I suddenly found myself saying, well, is this the way it happened? And I went up into the air and backwards as if I had practiced it 1,000 times and landed on a jury rail in perfect position like a mannequin, and the courtroom exploded, and from that moment on, that jury was mine. And I'll tell you, if you offered me $50 million to do that again, I couldn't do it, and I would appreciate $50 million as most men would. And there's your answer on how powerful the subconscious is. And the subconscious, and very often our subconscious reaction to a juror or to a human being is much better than our conscious one. So I say we use both, and very definitely.
Okay, we have a letter from one of our viewers, Judge. Hopefully you'll be able to answer this. He's been on juries in New York County time and again. Every 2 years he gets called down, he goes down to the courthouse, and he's never gotten on a jury. He wants to know why.
The solution is for him to move to Brooklyn. Because in Brooklyn, when we have a case on the calendar, we have a jury selected, and then the case is tried or it's settled. But we move our calendar, and we move it with dispatch.
Well, is there a secret way?
That's my job.
The answer is he better
I
change
know
his
that.
personality. That's the answer. There's something about that man's personality. There's something about his appearance. There's something about his mien that immediately causes a reaction on the part of the lawyers. Oh, this man we don't want. There are some men that obviously seem so opinionated. Just looking at him, you can tell, if you have any experience at all, and you know it just as well as I do. Just looking at him, you think to yourself, shucks, this man you can't shake in any respect. We don't want him. We want the reasonable man. And above all, if you're representing a plaintiff, you want the smiling man and not the scowling man. And you want the man who has about him the atmosphere of being a benign and generous-hearted person, a considerate person. You're judging people every minute of your life. So is every member of your listening audience. And all that you've learned in life and all that you've felt in life goes into the subject of picking that important juror.
But Harry, now you have described the type of a juror that a plaintiff would want.
I
Now,
want
that
you on
juror-
the defendant's side,
If that
Judge.
juror is everything that you want, and as you just described,
The other
the
fellow
defendant
doesn't
who
want
has
him.
the right to challenge peremptorily
We'll
that
throw him
particular
off.
jury, would throw him right off because
right,
he
Judge.
doesn't want an open, warm-hearted, generous
Absolute-
man. He wants somebody who's going to be quite frugal with the defendant's money, his client's money.
And so the jockeying comes into play between the lawyers in whom to throw off and whom in the panel that's left they might luckily get.
However, what the public may not know, but the lawyers do, is that there is a limit to the number of peremptory challenges that can be made.
Peremptory meaning that the attorney can just knock that juror off.
For any reason, doesn't like the color of his tie, doesn't like the color of his eyes,
Judge, let
doesn't
me,
like the color of his skin. Unfortunately,
Let me-
we have those who take jurors off their jury because of religious or ethnic or some other
Everything
ridiculous
plays
reason.
its
Judge,
part.
I know you've been sitting on the Supreme Court bench for years. Now, what I'm going
11
to do
to
is...
be exact.
What I'm going to do is, I'm going to take you off that bench for a moment. I'm going to make you a litigant, a party, somebody who has a claim. And now you have a choice whether to go
I
before a
settled.
jury. You have a choice whether to go before a jury or a judge, don't you?
You mean to say that I can pick a jury to try the facts, to judge
Or-
the facts?
or the judge to
Or
try
a
it.
judge to judge both the law and the facts?
Now you know it from both sides. You are a practicing attorney, and you're sitting in the Supreme Court of the state of New York.
Which
What would you
I choose? Every single time I pick a jury.
And Harry?
I definitely would prefer a jury because the combined intelligence of a group of people, no matter what their background, from the common sense they have from their everyday life, is generally likely to be much more accurate than that of the expert of where it's one individual on the
Judge?
bench.
And there's another reason. If a man's going to be a trial lawyer, he must have an ego, and it must be a big ego. And I don't say this in a deprecating fashion. I say it as a fact.
It's important.
Absolutely, Harry, you're
If he
correct.
doesn't have it, he doesn't belong in the
And
courtroom.
as long as he has that ego, he's going to pull what is generally referred to use a Brooklyn term, shtick. And he cannot pull shtick on a judge who's been there many times before, but he can pull it on a group of laymen and perhaps sway them.
Now, in Brooklyn and throughout the state, juries are picked by attorneys, are they not?
Yes.
There's a movement now in the legislature to have the judge select the jury, similar to the federal system. What's your opinion on that, Judge?
Well, first let me differentiate. We're talking about civil cases now, I assume.
That is correct.
Not criminal cases.
That is correct.
Right now, the lawyers pick juries in jury rooms which are very close proximity to my conference room. And I supervise the selection of every single jury in the County of Kings. I attend to questions between the lawyers as to whether a juror should be challenged for cause or not, such as bias, prejudice, etc. I determine whether a lawyer is entitled to question a juror on a particular facet or particular subject. So those jury selections on the civil end are in fact supervised by a judge. However, they run much more smooth with the lawyers selecting them themselves. And I find nothing wrong in that at all. On the criminal end, I do have a different viewpoint.
It's too
And
demanding.
what is that, Judge?
I believe that judges, under the existing law, there's no need to change the law, have not only the right, but the obligation to participate actively in the selection of a jury and to superintend it individually and to ask most of the questions, leaving a few questions for each lawyer to ask so that they can have the opportunity to attempt to ingratiate themselves in the eyes of the jury.
I
As they do
suspect
in the
Harry has some
federal-
opinions.
As they do in the federal court.
Well, right now, it's just a little bit different. It's not quite as...
Rigid as it was.
Yes, exactly.
A little more liberal. And they're becoming more liberal because, and this is my viewpoint too, because the judges know that nobody knows the case in question better than the lawyer who's lived with the case up to the point of trial. And that lawyer knows the general questions of the type the court alone is likely to ask may not cover the things that he should ferret out that might result in an unfair decision against his client. So he knows his case well enough to know, especially since he knows the proof that's going to come in, what he has to guard against and what type of juror he has to guard against, and he asks the questions accordingly. I'll give you an example. If he knows he's going to have a witness who's had a criminal record, but yet is a necessary witness who knows the facts in a particular case. The judge may not know that, or if he does, he may not be concerned about it. That lawyer will then ask the jury in advance, telling them that I'm going to have a witness who's had a criminal record, and he's paid his price to the state, And he's now out, and he's living a normal life, and he knows facts in this case as to which he'll testify. Now, will you listen to him with the same interest until judging of him as he testifies, and at least giving him the benefit of the doubt till you've had a chance to judge him, instead of closing your mind to anything he says in advance just because he had a criminal record?
But Harry,
Now, that's an example of one of the many situations that can't be
the lawyer has the
anticipated.
opportunity to write out these questions and a judge to put them in the proper form if they're not in fact in the proper form, and for the judge to ask that same exact question. However, here it's coming from an impartial source rather than an advocate. And we might have a finer strain of justice if that is done.
Well, I'm not so sure, Judge, because you can do all of the writing in the world, and you may not anticipate the answers that may come, and you may have a point of knowledge, further knowledge in connection with what is being discussed that the judge may not have, so that when the witness or the juror gives an answer, that other problem or that other situation that may be a difficult one to deal with unless the juror is prepared for it in advance is covered by the attorney. The judge cannot know.
But under
all
the
it.
state system as it exists right now, with the judge, in my opinion, having not only the opportunity but the obligation to actively participate in the selection of a criminal jury, in a criminal case, that is, we leave room for counsel to follow through, to ask additional questions, provided they're proper, subject to objection, subject to the court sua sponte injecting itself and determining that the question is unnecessary or improper.
Judge Held, if I may, there was another question I wanted to
Forgive
ask
me,
you.
Alan, we forgot about you, didn't we?
That's quite all right.
He's hard to
Harry-
forget, Judge.
Harry is famous for obtaining punitive damages in cases. Can you tell us what punitive damages are and when are they obtained?
Well, first of all, I thought Harry was famous for a lot of things. I didn't think it was necessarily or only for punitive damages. But
Gentlemen,
since-
you're spoiling
but
a humble man.
Since Harry is so famous for that subject, why don't we let Harry tell us what punitive damages are?
Harry?
Well, punitive damages arise out of unnecessarily wrong conduct. I'll give you a practical example. If you're going along at the speed of, say, 45 miles an hour in a 30-mile zone, that's carelessness.
Negligence.
That's right, negligence. And all that a jury can do is compensate the person for their injuries. But if that same driver is in an accident where he's going along cities of New York streets at 110 miles an hour, that isn't merely carelessness. That is a recklessness that is so dangerous that indulging in it in city streets, he shows a disregard for human safety. Now, when somebody...
Harry, the example you just gave, isn't that more of an example of negligence per se, rather than
Call it
punitive
what you will.
damages?
Judge, call it what
I think your verdict for
It could be
punitive
both.
damages would be set aside under your hypothetical.
Well, forgive me, Judge, if I take the liberty of occasionally disagreeing with the court.
Harry, you're an advocate, and I wouldn't expect anything less.
All exceptions noted, but the question I want to ask,
Well, then
which is
under
a
those
follow-up to punitive,
circumstances, under the circumstances I mentioned, if
Yes,
I'm
Harry.
right, in all due deference to the court, if I'm right, under those circumstances, the jury cannot only give compensatory damages, but they can spank the defendant with an additional sum called punitive damages to teach him not to do it again. And of course, the celebrated case in that regard is also an illustration. The one on the West Coast against one of the motor companies when they got a punitive damage verdict against them of $100 million. And there, they showed a disregard for human safety by eliminating an item that would have prevented the type of accident that was involved just to save $7 of expense on each car. And they showed a disregard for human safety, and the jury was allowed to render a verdict for $100 million against them.
Yes, in a products liability case, I can see an example of punitive damages. In a wrongful arrest case, an assault case, I can see punitive damages. For the malicious cutting off of utilities by a utility company, a cutting off of service by a utility company, I can see punitive damages. In fact, I had a verdict along those lines just last year,
But in line with that subject,
which was reversed by the appellate division.
Judge, you
and
reversed-
reinstated. No, the Court of Appeals corrected the appellate division.
Beautiful, beautiful.
Let me ask one question, and this will be for whoever wants to answer it. Recently, there was a matter right here in New York City of a grandmother who was shot and killed by a police officer when they were trying to either make her arrest
Jumpers case?
or evict. That's correct, Harry.
Alan, I will not comment on that, since that is a matter that might be pending. So
Can I ask?
Harry, as an advocate, certainly can answer it.
What is your question?
Well, the question is regarding municipal liability, Harry. Do you think it may very
Punitive
well
damages?
for punitive damages or otherwise?
Well, the city of New York can be held liable for the misconduct of a police officer if, number one, his record in the department is such that he has disclosed dangerous tendencies in the course of duty. If the municipality, the department, has had notice in his personal record that he has this habit or this tendency, then they can be held liable if he conducts himself, as his past indicated, dangerously.
Last question, Judge. There is now also a movement in the state legislature to limit medical malpractice awards to, I think, $100,000. What's your opinion on that?
I wouldn't want to be the victim of a malpracticing doctor under those circumstances. It's unfair, it's improper, it's totally against our sense of justice and fair play, and it's certainly against our system.
Harry, in the time remaining?
Oh, well, there's no question but that I agree with the judge. Can you imagine somebody suffering for the rest of his human life with a spine that has been of such nature that he's confined in the worst prison in the world, paralyzed on a bed from which he cannot move, and the limit is $100,000? What a shameful result that would be.
Harry Lipsig, Just Gerald Held, thank you very much.
And thank you for the
Thank you.
splendid host that you always are.
And to our viewing audience, thank you for watching Lawline.
You have been listening to Lawline with your host, New York lawyer Alan Schnerman. Mr. Schnerman will be back with you again next week at this same time.